Disinheritance is quite common. Spouses, children, stepchildren, adopted children, domestic partners, etc. all can be disinherited in many states. Not surprisingly, disinheritance often leads those disinherited to contesting the will, trust, codicil, or amendment that disinherits them. Whether you're a disinherited child, a disinherited spouse, an individual seeking to disinherit someone, or someone who is involved in a disinheritance case, here's a helpful guide. What's the definition of disinherited? What does disinherit mean? Disinherited, in regards to wills and family trusts, means to be excluded from receiving assets, money, or distributions from an estate or trust. What are the grounds for disinheritance? The person creating or amending a will or trust, referred to as the settlor, principal, testator, trustor, grantor, creator, has the ability to decide to whom to leave their estate and in what portion. Similarly, they have the same freedom to decide to disinherit someone. Generally, in regards to disinheritance, we most frequently see settlors disinheriting a biological child or stepchild. Some of the most typical reasons we see for child disinheritance: one, that they had no relationship with the child, either recently or going back sometimes decades. Two, the settlor understands or feels that a well-to-do child doesn't need more money or assets and therefore provides those assets to their other less well-to-do children. Three, the settlor has provided support previously or has other support plans for the child who's disinherited under a will or trust. Four, the settlor disapproves of the child's life choices, and that is often the most difficult thing to deal with. Fifth, the settlor feels abandoned by the child, especially late in life when perhaps the child is busy with their own life, children, businesses, and the parent feels abandoned, at which time very often they can be the subject of undue influence, perhaps by another child, a family friend, a caregiver. Next topic, is there a difference between being disinherited and being left out of a will? No. Colloquially, the phrases can be used interchangeably. Legally, there may be a difference. Generally, and colloquially, saying that you've been left out of a will or trust means that you simply weren't identified as someone to whom your loved one left a gift or a bequest. This can apply equally to a family member or non-family member who's not mentioned in a will or trust. In these cases, the non-family member has limited legal recourse if he or she was promised an inheritance or distribution. Conversely, a child or spouse may have rights if they were omitted from the document and it was created before the child was born or before the couple married. This is referred to as a pretermitted child or a pretermitted spouse. Sometimes the word omitted is used, so an omitted child or an omitted spouse. Here's an example. If a child or spouse is left out of a will, they may be able to still inherit. For example, if the decedent had 3 children, but only 2 were mentioned in the will because the 3rd child was born after the will was created, that 3rd child may have intestate succession rights that allow them to receive a share of the parent's estate even though they're not named in the will. For more information about intestacy rights and intestate succession, take a look at our website. We've got another video on it. Next topic, can I disinherit my spouse? The short answer is that it depends. Again, we've got another video on the site specifically on that topic. Take a look at it. But the short answer is that in many states, a spouse has legal rights to inherit from their spouse at least a portion of the estate, regardless of the deceased spouse's stated wishes. In California, for example, a spouse cannot be disinherited from his or her share of the couple's community property, although the spouse can be disinherited from the deceased spouse's share of that community property and the deceased spouse's separate property. These rights too could be affected by a prenuptial or postnuptial agreement. Consulting counsel in these cases to dive into and vet out these issues is critical. For example, if the deceased spouse includes directives in their will or trust that their spouse is to receive no assets, that is, complete spousal disinheritance, the spouse may still have a basis to seek a share of the deceased spouse's estate, whether as an omitted or pretermitted spouse under the party's prenuptial or postnuptial agreement, or as to their share of the couple's community property. If the surviving spouse is able to claim a share as an omitted spouse, he or she will receive both spouses' community property interests and at least 1/3 of the deceased spouse's separate property interests. 50% if the deceased spouse had only one child, and 100% if the deceased spouse had no children. If you are the spouse of a decedent seeking a fair and legal inheritance and have questions, give us a call. The consultation's always free. Next topic, can you disinherit a child? Yes. In most states, it's legal to disinherit a child. It's at the discretion of the person creating the will or trust. No legal reasoning or any other reasoning, in fact, is required to disinherit a child. However, simply leaving a child out of a will is not the same thing as expressly disinheriting a child. A biological child that is not mentioned in a will may still have the ability to claim a share of the estate as an omitted or pretermitted child. If you are a child seeking your inheritance and have questions, again, give us a call. We're happy to give you a free consultation. Next topic, can you disinherit a domestic partner or common law spouse? In common law states, which California is not, a domestic partner or common law spouse may have a right to inherit. In non-common law states, the domestic partner or common law spouse may have no inheritance rights. And in another twist, in some states that recognize common law marriage, unlike a spouse in a legal marriage, a common law spouse can be disinherited, where perhaps a legal or traditional spouse could not. Each state's laws are different. In California, simply living together never establishes a common law marriage, although other claims and remedies may be available under Marvin and other theories. However, two people can enter into a domestic partnership agreement in California, and registered domestic partnerships offer many of the same legal provisions and protections as a legal marriage, including inheritance. However, just like a spouse, a domestic partner can be disinherited and omitted from a will or trust. This often leaves the door open to litigation for the surviving domestic partner. Can an adopted child be disinherited? Yes. Just like a biological child, an adopted child can be disinherited. The same requirements apply. That is, that the settlor clearly stated their intention to disinherit the adopted child. Similar to a natural child, an adopted child too may claim an intestate share of their parent's estate as an omitted child or pretermitted child if the will or trust was created before the child was adopted. Next topic, how do I disinherit a child in a will? First, you have to prepare and execute a will. In that will, you need to state your intentions to disinherit the child clearly. You do not need to state the reasons, only who the child is and that they're being disinherited. Then keep the will in a safe place, tell the executor of the will where you keep it, and perhaps provide them a copy for safekeeping. You can create a will yourself, use an online service, or seek the help of an estate planning attorney. Second, although not necessary, in order to help the other beneficiaries avoid, win, or minimize the impact of potential litigation, the settlor or preparer of that will should also prepare a letter of disinheritance, stating the reasons why the child is being disinherited. Although this is difficult emotionally, these clearly stated explanations will make the settlor's intentions clear, limiting the disinherited child's ability to seek inheritance through litigation after the settlor's death. Third, if the principal or preparer or creator of the will is using the service of an estate planning attorney, they should make it clear to the planning attorney that the child is being disinherited and why. The attorney acts as a legal witness, a scrivener, and usually documents the disinheritance and the reasons for it, all of which evidence can be very persuasive should litigation arise after the death. Lastly, if an individual suspects that probate litigation is likely to occur after their death, especially in estates with significant assets, then the individual might want to consider adding an additional layer of protection to their planning in the form of a certificate of independent review or in obtaining an expert evaluation who can verify the settlor's capacity, the lack of undue influence, and the reasons why the disinheritance occurred. A contemporaneous written evaluation blessing the will or trust that disinherits someone can be a critically helpful piece of evidence in protecting your efforts to disinherit someone from their later attack. Next topic, can you disinherit someone if there's no will? No. Some testamentary document, either a will or trust, clearly stating your intentions is required to disinherit a child, spouse, etc. If you don't take the time to prepare a will or trust, then the laws of intestate succession will dictate who inherits what from your estate. Next topic, does California have a disinheritance clause? California does not have a disinheritance clause. To the contrary, California's estate laws, codified in the California Probate Code, dictate that intestate estates will be distributed to a decedent's spouse and children, or if none, then to their family. No one is specifically disinherited under the California Probate Code. Next topic, what is a disinheritance letter? Generally, a disinheritance letter is simply a communication prepared by the creator of a will or trust to demonstrate to a child, spouse, etc., the reasons why the settlor has disinherited them. The disinheritance letter can be an important tool because it provides insight into what the settlor wanted. That is, the reasons why they disinherited a person. Next topic, can a disinherited child contest a will? Yes, a disinherited child has the legal right to contest a will or trust, especially if they feel the decedent lacked the mental capacity to make sound decisions, or if the decedent was pressured by somebody to disinherit the child via undue influence or duress. We routinely represent children, spouses, and other people who are disinherited by someone due to undue influence or duress applied by a step-parent, caregiver, or other abusive family member or interloper. Historically, we've been able to recover substantial inheritances in these cases. If you have a question, please feel free to give us a call. Again, the consultation's always free. Can a disinherited spouse contest a will? Yes, a disinherited spouse also has the legal right to challenge their disinheritance. Next topic, I've been disinherited. When should I contact a probate litigation attorney? The moment you suspect or learn you've been disinherited, you should contact a probate litigation attorney near you. Evidence is critical to proving your case, and if you delay, critical evidence may be lost. Take advantage of a free consultation and protect yourself and your inheritance. Do I need a probate litigation attorney near me? We recommend finding an experienced probate litigation attorney familiar with the county probate court in the county where the decedent lived and their estate's being administered. For example, if the decedent was in Los Angeles, we recommend working with a probate litigation attorney in Los Angeles. That Los Angeles probate litigation lawyer will be more familiar with the Los Angeles probate court than an out-of-state or out-of-area attorney. Have questions? Give us a call, shoot us an email. The consultation's always free. We're happy to help. Thanks for watching.